Attorney Atty.Kaufman, good afternoon.
Good afternoon.
How are you today?
I'm well, thank you. So is the former president, of course,
Thank you, Attorney.
more importantly.
Attorney, the pretrial chamber, one, recently rejected the renewed request for interim release, which you described as erroneous. Could you exemplify what makes the decision, in your view, legally and procedurally flawed?
When I describe a decision as being erroneous, I'm using legalese. It's a term that we have to use if we're going to make an appeal, because appeals are decided on the basis of errors of law and errors of fact. So we have identified what we believe to be a number of errors of law and fact in the decision on interim release. We've filed our notice of appeal, and today we've filed our brief in which we give our reasons for these alleged errors. Now, I'm not allowed to obviously detail those errors because the document has been filed confidentially.
Attorney, do you believe that the pretrial chamber, one, failed to properly consider all or any of the key arguments or evidences presented by the defense?
As I said, I've raised a number of issues on appeal, one of which is the failure to properly consider the very stringent conditions of release which were proffered by a state party. I'm not going to tell you which state party that is, but we believe that the first instance chamber, pre-trial chamber, should have taken these things under consideration and give a better weight to them. We believe that that was an error, but once again, I don't want to get drawn too much on the exact nature of the appeal. I'm not allowed to detail it.
Attorney Nick, the pretrial chamber, one, in its decision, has taken into account the public statement made by Vice President Sara Duterte. Do you consider this a form of injustice or a breach of judicial impartiality?
I don't want to comment on that, but some of the statements that were made by the Vice President were clearly made in jest. I mean, there was this comment about organizing a jailbreak, and I have to laugh at that, quite frankly. Everybody who hears that knows that it was a joke. No one can really seriously believe that the Vice President of a sovereign nation would organize a jailbreak from a place like this. I mean, come on, let's be real about this.
Because, Attorney, I was there when the Vice President made those statements.
Yes.
Yeah.
And you understood it as a joke just like everybody else.
Exactly, Attorney. Attorney Nick, in what ways might this inclusion of such statements influence directly or indirectly or prejudice the pretrial chamber one's decision-making processes?
Well, I think that excessive comments on the judicial activity is not something that should be encouraged. The judges of the International Criminal Court have a job to perform, just as counsel have a job to perform, and they shouldn't have their every act scrutinized in the media. Once again, I give the judges the credit of performing their duty as is expected, and I hope to convince them now on appeal that the former president should be released.
Attorney, in what ways should we take into account the timeline for the court to make or to render judgment to the appeal that you have submitted?
You mean a judgment on the interim release,
yes,
on appeal? Well, once again, the liberty of the individual, interim release, is a fundamental right. Obviously, that right can be curtailed if the judges find that there is cause to curtail that right. And the curtailment of that right is founded normally on three factors, one of which is the risk of flight, one being the risk of interference with witnesses, and the final one being the risk of continuing commission of crimes. But as I said, it's a fundamental right which should be decided speedily, expeditiously, and I anticipate that once the pre-trial chamber has received all the submissions, obviously the prosecution will have to respond to our appeal, and also the victims will be given the opportunity to respond to our appeal. I anticipate that a decision should be rendered within the month.
Within a month, okay. Attorney, while the appeal on the appeals chamber's decision, on the pretrial chamber one's decision is still pending, are all related motions filed by the defense being reviewed simultaneously?
What do you mean by all other motions?
I mean, like, obviously there's a decision by the appeals chamber with respect to the motion you submitted to disqualify the chief prosecutor can, but all of the other pending motion, indefinite adjournment, jurisdictional challenge, and
Yes, all of those matters are still live and active, and the appeals process on interim release does not impact on the timeline or the schedule for deciding other matters. In fact, we are busy, as you know, at the moment, litigating the issue of competency, fitness to stand trial.
Yeah.
I'm not at liberty to tell you exactly what's happening there, because once again, much of the information is subject to confidentiality. And I should like to stress that also in the matters relating to the former prosecutor, sorry, he's not the former prosecutor, he's still a prosecutor. Obviously, he's taken himself out on suspension. However, a decision on our request to disqualify him is, to the best of my knowledge, still subject to confidentiality.
Attorney, on that particular note, do you think that there is a reason to think otherwise, that the ICC handled all of the processes or the motions that the defense submitted with sufficient fairness and transparency?
I don't want to pass judgment on the ICC judges. It's not my position to do so. They have a job to perform. I have a job to perform. They make their decisions. If I believe that these decisions are erroneous, and I've told you that is legalese, then I file an appeal, and then the judges on appeal decide.
Attorney Nick, on a different matter, several civil society organizations have welcomed the Prosecutorial Chamber's once decision, expressing relief over the denial of the former president's interim release. How does the defense team respond to this public sentiment?
Well, I'm not going to criticize victims. It would be foolhardy for me to do so. I do criticize, however, the comments made by certain civil society activists, masquerading as lawyers sometimes, in the media, criticizing defense submissions, criticizing defense activity, criticizing decisions rendered either in favor of the defense or against the prosecution, whatever you have it. So the criticism, or can I put it, the relief, as you put it, expressed over the rejection of the former president's request for interim release, I believe to be misplaced. And once again, there are many things that I could talk about which offend me. Many things said by civil society activists, which I choose not to comment on.
Attorney, do you think that these reactions reflect a misunderstanding of the legal process, or do they reveal, rather, deeper political or emotional divides within and outside the Philippines?
Well, let me talk about outside the Philippines first of all, because wherever I go in the world, and I travel a lot, I have always been met with support, wholehearted support for the former president. I have not come across one person who has said, we don't want the president to come home. Everybody wants him to come back to the Philippines. So when you talk about dissent, there's certainly no dissent in the diaspora. Not at any rate dissent that I've noticed. So I don't think that the criticism reveals anything too much. It just reveals the thoughts and impressions of a minority of civil society activists.
Attorney Nick, some detractors have criticized your handling of the case, suggesting that the Duterte family should consider appointing a new lead counsel. How do you respond to these criticisms?
Well, I know who those detractors are. A minority of people, a very vocal minority of people. At the end of the day, I'm not a magician. I'm doing my job. I'm doing the best I can. And furthermore, the former president is happy with me. And at the time that he should become unhappy with the way I'm performing, then he knows that he can fire me.
Attorney, what would you have to say to those who believe the defense strategy has not been effective so far, and how do you intend to strengthen your legal approach moving forward?
Well, it depends how you define success. If you define success in the matter of interim release, well, okay, we still have an appeal pending, and that's the only thing we've been unsuccessfully to date. The matter of competency is still pending. The matter of jurisdiction is still pending. Obviously, we've had a few requests to disqualify judges dismissed. I can't tell you what has happened with respect to the decision on the the current prosecutor who's now suspended. Maybe that will be released soon. I don't know.
Attorney Nick, just a quick moment or question with regards to the decision to disqualify the chief prosecutor. Does it have any effect at all, if at all, to the case of the former president before the ICC?
Once again, I can't comment on a decision because I don't know whether that decision has been made public or not. I can only tell you what I argued. What I argued was that the former prosecutor, I keep on saying the former prosecutor, it's the current prosecutor, current chief prosecutor, who has suspended himself. What I argued was that being conflicted, as I argued that he was, he couldn't have carried out an independent investigation which requires the search for exculpatory evidence. What is exculpatory evidence? That's evidence which can be used to acquit the former president. You see, the Office of the Prosecutor has resources that the defense doesn't have. And the Rome Statute, which is the constitution of the court, obliges the prosecutor to look for the truth. And by looking for the truth, he also has to consider exculpatory evidence. So what we argued was that having a prosecutor who formerly represented victims suddenly changing sides and becoming the prosecutor, he can't really carry out his role as the prosecutor as should be expected. So effectively, the investigation was contaminated. When he represented those victims, it was back in 2018. When the arrest warrant was issued, it was 2025. He became prosecutor in 2021, 2022. So 3 or 4 years went by when he was supervising the investigation against the former president, yet not disclosing the fact that he'd formerly represented victims.
What?
As I said, I can't comment on any decision that might have been rendered.
Just really one question in that regard. Would it be fair to say that because the appeals chamber decided that to disqualify him from further involvement, that all of this development in the case can be characterized as the fruit of a poisonous tree? That
Alvin, I can't comment on that. As I've told you,
Sorry.
I don't know what the decision to release or not to release this information is at the present moment in time. I've been in a prison today.
Okay, sorry about
I
that.
can't tell you if there's a public decision on the matter or not.
Okay, I'm sorry
For all
about
intents
that.
and purposes, I don't know what the decision is, and I can't tell you what the decision is.
Attorney, one last question. Do you have a message to convey to the Filipino people closely monitoring the case of the former president?
Yes, I do. Be strong, hope for the best, and trust us to do the very best for the former president.
Thank you
We're
so
working
much.
hard. We've made an appeal. We hope that he will be released and that he will continue to follow the case, continue to participate in the case, continue to allow his lawyers to prove his innocence, and all this, not from the Philippines, but from a third-party state country, a state party to the Rome Statute.
Thank you, Attorney.